Preparation for Railway Departmental Examination or other railway competitive examinations can be done with the help of this video. Today's question: what are child adoption leave and child care leave and what are their rules? Answer of child adoption leave, child care leave. Child adoption leave. An adoptive mother on the railways with less than 2 surviving children may be granted leave of 180 days as child adoptive leave on adoption of a child up to 1 year of age, on the lines of maternity leave admissible to natural mothers. During the period of child adoption leave, she shall be paid leave salary equal to the pay drawn immediately before proceeding on leave. Leave may be combined with leave of any other kind. In continuation of child adoption leave, the adoptive mothers may also be granted, if applied for leave of any kind due and admissible, including leave not due and commuted leave not exceeding 60 days without production of medical certificate, for a period up to 1 year reduced by the age of the adopted child on the date of legal adoption without taking into account the period of child adoption leave, subject to the following conditions. 379. This facility will not be available to an adoptive mother already having 2 surviving children at the time of adoption. 1. The maximum admissible period of 1 year leave of the kind due and admissible, including leave not due and commuted leave up to 60 days without productions of medical certificate, will be reduced by the age of the child on the date of adoption without taking into account child adoption leave as in the following illustrations. If the age of the adopted child is less than 1 month on the date of adoption, leave up to 1 year may be allowed. If the age of child is 6 months and alive but less than 7 months, leave up to 6 months may be allowed. If the age of the child is 9 months and above but less than 10 months, leave up to 3 months may be allowed. Child adoption leave shall not be debited against the leave account. R. B's number A, P and A, 1 2006, CPC, L 1 of the 18th of May 2006, Baharis 62 2006 and Baharis 166 2009. Child care leave. Child care leave, introduced from 1.9.2008, sad face, 1. Women employees having minor children may be granted child care leave by an authority competent to grant leave for a maximum period of 2 years, i.e. 730 days, during their entire service for taking care of up to 2 children, whether for rearing or to look after any of their needs like examination, sickness etc. I. Child care leave shall not be admissible if the child is 18 years of age or older. E. During the period of such leave, the women employees shall be paid leave salary equal to the pay drawn immediately before proceeding on leave. IV. It may be availed of in more than one spell. V. Child care leave shall not be debited against the leave account. V. Child care leave may also be allowed for the 3rd year as leave not due, without production of medical certificate. V. It may be combined with leave of the kind due and admissible. V. Child care leave shall be admissible for 2 eldest serving children only. X. The leave account for child care leave shall be maintained as per prescribed pro forma. R. B's number A, P and A, 1 2008, CPC, L 8, dated 2/3/10/2008, Baharis 158 2008. It has been decided to permit CCL to female railway employees having disabled children up to the age of 22 years subject to the other terms and conditions stipulated in Board's letter the 23rd of October 2008 and 12.12.2008. Disabled child having a minimum disability of 40% as elaborated in the Ministry of Social Justice and Empowerment Notification No 16 and 1897 NEL dated 1.6.2001. Documents relating to handicap as well as a certificate from the railway servant regarding dependency of the child on the railway servant would have to be submitted by the female railway employee. R. B's number A, P and A, 1 2008, CPC, L 8, dated the 23rd of April 2010, Baharis 58 2010. Clarification. I. CCL cannot be demanded as a matter of right. Under no circumstances can any employee proceed on CCL without prior proper approval of the leave by the leave sanctioning authority. E. The leave is to be treated like the earned leave and sanctioned as such. E. Consequently, Saturdays, Sundays, gazetted holidays etc. falling during the period of leave would also count for CCL, as in the case of earned leave. IV. It is further clarified that childcare leave sanctioned prior to the 18th of November 2008 shall be treated as childcare leave and shall be deducted from the childcare leave account of the railway servant concerned. No adjustment against any other kind of leave shall be made in this regard. The childcare leave sanctioned for the period beyond 18/11/2008 shall be regulated in term of clarification issued with OM dated the 18th of November 2008, ABS number A, P and A, 1/2008, CPC, LR 8, dated 12.12.2008, Baharis 195/2008. V. CCL can be availed even if the employee concerned has earned leave at her credit, subject to the following conditions. A. CCL may not be granted in more than 3 spells in a calendar year. B. CCL may not be granted for less than 15 days. C. CCL should not ordinarily be granted during the probation period except in case of certain extreme situations where the leave sanctioning authority is fully satisfied about the need of child care leave to the probationer. It may also be ensured that the period for which this leave is sanctioned during probation is minimal. Date of per and TRG OM number 13018/1, 2010 ist. Leave, dated 7.9.2010.